Order for breaking news, Kessel and Miss Ansodi in our bro, I will Ghana to Becca. I say, no issue and I say breaking news, air trendy or Ghana. I say, a new suit. I am a Gertrude Torkornoo filing. I did here a year acting Chief Justice. I am poor Bafuboni. You see, what I say, we see, say, young haughty vetting process no, of Paul Bafuboni as the new Chief Justice of the Republic of Ghana. Or say, process now, ye kakaka ni film say, acting and appointed Chief Justice of the Republic of Ghana. No, or say, sa process no, omun halting, omun stopping. No. Because ono ankasa na sem no munya din wiye. E na chese odofo amanfo bebre na ba abonti no beka se, ye maame ankasa ye kasa che na ontie. Enkan ni menim ya nka e ka se nkon resign no, nko eno anse nko de pen, atu paper so na nka wa den. Wacho se ono ankasa no wa den, wa resign na nko copy bebi ntina. Na nka eye niama ese fata ni nyina sika bia na se eye akadia bia ese fata ni bia na kedni nyina e de aka ho ama no sika bia ese fata no se eye remuneration bia ana se niama bia o resign e de man nyina no na kede ama ne kama se na be ya wonya na sumdwe but essence na so ye de na obeso beti asem no ona wanye na adwin so be resign no eni nti a je se ende no ofali case no na we lose no ofali case na che se ofali case we a ontwen ni endi case ni wie no asen file fofo che se sana manama we nyina no ye maame aswodin a eda na so onye na adwin se obetie Ghana fo nka enimeni ekokohu John Dramani Mahama yesi ekokohu John Dramani Mahama secretly on office no catching so okay chale yentina sinenka business adase yentina sinenka asem we disi an bese me resign it say akade bia me sefata bia na mo fama me orofo omose nko ye ne saa enkase nka tim 210 ne wato no na nye se ende no nam high court ne educate nam supreme court na ende nam ECOWAS orofo we na Ghana fo bebre na omu criticize ye ma me se na so odin na de na bebi sam pempensu we orofo manko ye go jisanse mu nyina nchiremu e Ghanatube na maisia
so as to tick all the boxes, bring clarity, form a strong precedent so that we'll see how the days and years ahead will look like. Before you answer that, let me acknowledge Bracco Powers is a private legal practitioner as well joining us. So Powers, good morning. Thank you for joining us.
Good morning.
Perfect. Where's Flōw?
Okay. I'm not surprised that now removed Chief Justice Gertrude Araba Saki Torkornoo had decided to file this judicial review application. I'm not surprised at all.
Why doesn't it surprise you?
The reason is simple. You see, Alfred, as young as I am, there are certain things that when you are advised and you decide to do otherwise, it goes against you. Look, in the midst of these petitions, two prominent Ghanaians said, look, if the Chief Justice wants to resign, she should be permitted to resign. I recall vividly, the argument was made. The Constitution says, and the Supreme Court has clarified the issue, that once an Article 146 process has commenced, you do not have the option of resigning. At that time, there was a strong push that, hey, Justice Torkornoo had worked High Court, Court of Appeal to Supreme Court. And therefore, that matter, for her service to this republic, she should be permitted to resign and take her emolument. So she can go. At least when she resigns, she is entitled to her benefits. Just when they were waiting for that, from nowhere she decided to do a judicial process, somersault. I think today, she's come to the realization that she ought to have resigned instead of allowing the process to go through.
You said that was not on the table.
Please, I know, and for this privileged information, I cannot even name the people.
Amanda also came and said it.
Look, two prominent people.
And we supported it here. Remember, you and
I was opposed to it. You said, look,
yes,
it should be allowed, even though the Supreme Court, because what had happened was that there was a High Court judge who Article 146 process had started against him.
Yeah.
Then President Mills was in the process of putting the committee together. The CJ then, Georgina Wood, started the process. Then the judge, knowing that if that Article 146 committee concludes its work, he stands the risk of losing his entitlement, quickly tendered in his resignation. So the question was whether President Mills was bound to accept the resignation. And the Supreme Court interpreted the matter and said, once an Article 146 process had commenced, there is no option. If not, you defeat the very purpose of Article 146. But you see, we are back to this point because her ladyship, the Chief Justice, now removed. Options are completely gone. Completely gone. The options are gone. Let's look at the legal issues now. I've gone through the judicial review processes and the attachment. I spent yesterday reading through it. Now, if you look at the grounds of the judicial review, and if you look at the things and the reliefs that she is seeking, you come to one irresistible conclusion. An appeal of the Puaman-led committee and its work disguised as a judicial review.
It's appealing.
It's an appeal, but disguised as a judicial review application. But you see, as lawyers, we have the skill set to uncover and to unwrap these wraps that she had put on the processes. Because essentially what she is saying is that the Puaman-led committee had done its work, but I disagree with their findings and the conclusions reached and their recommendations. And for that matter, I want a high court to have a second bite. That is not allowed by law.
After she has been removed.
Yes. That is not allowed by law. And the reason is simple. In the wisdom of the framers of the 1992 Constitution, they didn't want an Article 146 proceedings to be appealable. And so when they were creating the Constitution, what they did was that when it's a commission of inquiry under Article 284, you are permitted to appeal. So it says that a person dissatisfied with the findings of a commission of inquiry, like Brazil, Ghana at 50 or this, you have the right of appeal. So finality is not in the work of that committee. It can be judicially reviewed or through a high court intervention. So in this case, what you do is that you allow the high court when it comes to a commission of inquiry, but here you go to the court of appeal. And that is why for lawyers we say an appeal is a creature of statute.
Right.
There must be a statute that creates that right. Now when she looked at the option, she realized that no, there is no right of appeal envisaged under Article 146. So by legal ingenuity, try to come out with a judicial review, but to achieve the same end of an appeal. Because in an appeal, we say appeal is by way of rehearing. And so if you look at her relief, what she is seeking is to have a high court judge now sit and say, okay, the Puaman-led committee, you have done your work, but to my mind as a judge, you were not fair to Torkornoo. Basically, to have that high court judge now sit in judgment over the Puaman-led committee, that is unconstitutional. That is constitutional lawlessness. Complete constitutional lawlessness.
You describe this as
complete constitutional lawlessness and should not be entertained.
So she's accepting
let me tell you, if you look at grounds 1 and 2, reliefs 1, 2, 3, and 4. What she's doing is to say that the committee says I'm not fit and proper by reason of the findings of stated misbehavior. Right? However, to my mind, I am fit and proper to hold the office of Chief Justice. What you must understand is that under our constitution, there is only one set of group or a group of people who can make that determination. Not even the Supreme Court. It is only the committee set up under Article 146. And so, in the year 1994, the Ghana Bar Association decided to test that fitness question in the Supreme Court in what is known as the Urban case. The Ghana Bar Association versus the Attorney General, popularly called the Urban case. What was it about? President J. Rawlings had then made Urban the Chief Justice. The Ghana Bar Association quickly issued a writ at the Supreme Court. In that writ, all they were seeking to say is that Justice Urban does not meet the constitutional threshold of becoming a Chief Justice. What they wanted to do through the back door is to trigger Article 146 proceedings by using a writ of summons. Justice Pega, Ajabi and Co. saw through the rules and said, hey, please. You are afraid of Article 146 proceedings. So essentially what you want to do is to use the writ action under Article 2 to basically achieve the same outcome. We will not permit you. And if you read the judgment of the Supreme Court in the Urban case, my Lord Justice Pega had this to say. He said, look, as lawyers, as the creme de la creme of the legal profession, we expect better from you. And that, listen, the reason for Article 146 and its in-camera proceedings is to preserve and protect the independence of the judiciary and not turn an Article 146 proceedings into a theater like it usually happens in the courtroom. Now, what essentially now removed Chief Justice is doing is that if she successfully triggers the jurisdiction of the judicial review jurisdiction of the High Court, essentially what she's doing is to put the Praman Committee, which otherwise is supposed to be in camera, to now an open conversation. That is where the constitutional lawlessness is. Because now that she had filed, if you respond to it, you have to come and do a merit review of the work of the committee.
But you're essentially questioning the basis for her removal.
Exactly. And so the committee's work is supposed to be in camera. Now, immediately you put it out in the court. Court proceedings are not in camera proceedings.
To strengthen your argument, but the Supreme Court in the Derry case said after it's over, they should release it. No, it's broken.
No, I'm coming. So the point that we all need to appreciate is that in the wisdom of the framers of the Constitution, they did not make the work of the committee under Article 146 a subject of judicial review. The judicial review powers envisaged either in CI 47 or the Constitution itself to the High Court does not include the workings of the Article 146 committee. And the policy rationale is to preserve the in-camera status of the work of the committee. Because you see, at this point, if she succeeds in her action in triggering the jurisdiction of the High Court, what it means is that the AG by law would have to file affidavit in opposition. And in that affidavit in opposition, depends to the fact that the committee's work and whatever were all fair. So what it means is that you have to bring the works of the committee before the judge.
And in fact, there's been calls that to the extent that the committee has finished and submitted the report.
Finality.
That report should be made public.
Yeah, the Supreme Court itself says so. In the Derry case,
you see,
it says they are not against publication, and we are waiting for it. We must get those reports.
The danger,
we must.
I know my senior brother Martin Kwebu. Martin, when it comes to issues about legal matters, if you don't put a chain around him, he can run, for want of better word, run very rogue. and please, and stretch the law to a position that if we are not careful, we may have to rewrite the Constitution. And people has the tendency of rewriting the Constitution, using advocacy. But that said, what we should not allow in this circumstance is to permit a high court to sit in judgment over an Article 146 committee disguised as judicial review. In the superior wisdom of the framers of the Constitution, that was never envisaged. I recall vividly, you remember Zachariah Nyimakan?
Yeah. The Willency constituency.
The Willency constituency matters. After that, Nyimakan appealed right up to the Court of Appeal, because in that case, the Constitution is clear that, a petition, the High Court petition, should end at the Court of Appeal. Nyimakan wanted to test his, whatever you call it, by putting up an appeal further from the Court of Appeal to the Supreme Court. The Supreme Court itself denied itself that jurisdiction. Yes, of course, the beautiful dissent by her ladyship Sofa Akufo, as she then was not enough to get the majority to side with her. Because even then, the majority were of the view that if the framers of the Constitution intended that there should be a federal right of appeal relative to an election petition, a parliamentary election petition hearing to the
Orofo ensem no aidija chese ye maame ye se na so den ena de na kwakudu sa mpempenso no at least no enkotie futu no ko resign peacefully ya enka na asem no nke escalate enkodu sa level we enti ye se ye maame na so den ena ede na bebidu sa mpempenso we ya waba bedu de no file case wa ha oche no nam high court na ade chinse no nam supreme court no nam ECOWAS court na ade nyina ye se enkotie eno nko ne mpanyifo John Dramani Mahama mpanyifo court na ase eno resign asumdwe mu na nka ne benefits na ade nyina esafata ne nyanko mode mana enka no antintontan enka ne case ne nyina nka koda din ba esan so na nka so pese o kire se onimra esan so pese o kire se oye Supreme Court judge and also Justice of the Supreme Court also Chief Justice of the Republic of Ghana and also Justice of the Supreme Court nto peso chese onim emrano anintia chese ompeso beti obi ana sema ndo nam ha no chino nam ha ena inde ne ho aba asem dendenden a obi aka ho asem no ntini wei ena breaking news a efi social media ne so justice and I say retired Chief Justice and I say sacked and I say removed Chief Justice Gertrude Torkornoo officer meso amedin nyina bro Ghanatube form we fi sembe like no ma subscribe no ma share no ma hit notification board so ma say the be abia drop content say ya wo wonya ne tempa no wa hwe with amado for aha na be nsem nyina be see Ghanatube so makra mu nyina medamu nyina se bebre